Good evening, everyone. My name is Lainey Humphrey, and I am the Programs Assistant here at the library. I wanted to thank everyone for coming to this program, including our presenters, Leslie Rodriguez and Anik Abarad. For today's program, the North Suburban Legal Aid Clinic, the NSLAC, will discuss the rights of renters with regards to lockouts, landlord disputes, and more. Before we get started, there's just a couple of reminders. This presentation is being recorded and live streamed to YouTube. At the end of the presentation, we will stop the recording and the live stream. If you have any questions, please feel free to write those in the chat box or in the Q&A box. Closed captions are enabled. Click or tap the closed caption icon in your Zoom tools on your computer to enable or disable live captions. Also, upcoming programs that you might be interested in, we want to always remind you of. One is identifying and growing native plants. That's going to be on Tuesday, March 29th this year at 7 o'clock to 8:30 p.m. Nancy Lamaya will guide us through cultivating and identifying plants that are native to Illinois. And now about our presenters this evening. The NSLAC provides free, accessible, quality pro bono legal services in the areas of immigration, domestic violence, and housing to give those in need of access to justice, and those in need of access to and the opportunity to live productive and secure lives. The NSLAC services Lake and North Suburban Cook County. You can call 847-737-4042. Again, that's 847-737-4042 to make an intake appointment. Anik Abarad is a multilingual law clerk with a passion for helping those in need. Before joining the clinic, Anik was a law clerk at a private family law practice. Community advocacy has been a longtime passion for Anik. As a young student, Anik worked as a local library program coordinator for youth and family events. So it's coming full circle now. And Leslie Rodriguez is a housing community navigator focusing on community outreach with specific attention to addressing the eviction crisis, which has been heightened by the COVID-19 pandemic. And now we have those introductions. I'll turn it over to Leslie and Anik for their presentation.
Thank you, Lainey.
Thank you.
Let me quickly share my screen. Okay. Welcome, everyone. Thank you for joining us tonight. My name is Leslie Rodriguez. I'm the Community Navigator for the North Suburban Legal Aid Clinic. And tonight I'm accompanied by my coworker, Anik Abarad, the Housing Law Clerk for the North Suburban Legal Aid Clinic. She will be covering the portion of the presentation that covers eviction and the eviction process. So when that time comes, I will turn it over to her. Without further ado, let's get started. So just to quickly go over the content of the presentation for tonight, we're quickly gonna go through the North Suburban Legal Aid Clinic's overview, cover our general services, I'll talk a little bit about each practice, and then also go over how to reach us and set up an appointment to talk to an attorney. We will then go over to talk about tenant rights, the eviction process, COVID-related policy, rental assistance, and more specifically, court-based rental assistance. Here at the North Suburban Legal Aid Clinic, our mission is to provide accessible, quality, pro bono legal services in the areas of immigration, domestic violence, and housing, to give those in need of access to justice the opportunity to live productive and secure lives. All of our services are free. We have 3 practices here at the clinic, the domestic violence practice, the housing practice, and the immigration practice. Each practice has different services that they can provide to their clients. And sometimes we do see some overlap between our clients' needs. Like if we have a client that comes to us and has both a housing issue and a domestic violence issue, our practices will collaborate to address the issues that the client is facing. Here's a brief list of some of the services that our immigration practice can address. They assist with visa petitions for spouses, children, parents, and siblings, visitor visa petitions. They assist with consular processing, citizenship, green card renewals, U visas, and T visas as well, asylum, and DACA renewals, as well as VAWA self-petitioner. This is the Violence Against Women Act self-petitioning. If you have any questions regarding your immigration status, or just generally want to learn more about what type of immigration benefits you might be eligible for, feel free to give us a call to talk to an attorney to continue discussing this matter. Our domestic violence practice can help with a variety of legal issues. They can address any type of family law matter as long as there is domestic violence occurring in the relationship and in the family. They can assist with civil emergency orders of protection proceedings, as well as plenary orders of protection proceedings. They can help with civil firearm restraining orders, divorce proceedings, as well as parental allocation proceedings, DSFS proceedings. They can advise and counsel survivors whose abusers have been criminally charged. And something just as important, they are able to coordinate social services for survivors and their children or family members. This is a brief list of the housing services that our housing practice can address. Something to note is that the housing practice at the North Suburban Legal Aid Clinic only addresses and assists tenants. We do not assist homeowners. So that is something to consider when setting up an appointment with our clinic. I'm not going to go into detail for these right now because I will cover this at the end of the presentation, but just to throw it out there, this is a brief list. If you would like to contact us, please feel free to call 847-737-4042. We have recently moved. We are located at 3500 Western Avenue in Suite 2A in Highland Park, Illinois, by the Starbucks over in like the Fort Sheridan area. We're there from Monday to Friday from 9 a.m. to 5 p.m. We speak Spanish, Korean, and Polish, but we also have an interpreter service available for clients who might speak other languages. And if you would like to make an appointment to talk to an attorney, you can also visit our website and request an appointment via our website, which is right here, or by emailing this email. Now let's jump into tenant rights. To get started, let's discuss how to find the right unit to rent. When you're looking for a new unit to rent, a new place to sign a lease for, you should ask the landlord a variety of questions like how much the rent is going to be per month, when the rent is due, how to pay rent. Sometimes this can be done virtually, like through a portal. If there are any late fees, if you, for some reason, end up paying your rent a little bit late, how long the lease will be for, when the lease will start, who's going to pay for utilities. Sometimes this varies depending on the landlord, what the average monthly costs for utilities are currently for like the tenants. Sometimes you can ask this sort of information from neighbors if you're visiting the unit. You should also ask how much the security is going to be, if there is a security deposit, or if there's a move-in fee, as well as who's responsible for repairs if repairs are ever needed. Like I mentioned, you should also try to talk to previous tenants or neighbors if they're available, just to get a sense of what the relationship is like with the landlord, if they make repairs, if they address the needs of the tenants, if they've ever had any problems with the landlord, and if they have trouble with loud noises. When you're applying for a rental unit, there typically are a list of things that a landlord will request from someone who's applying for that rental unit. A landlord will typically run a background check, like a request a background report, as well as a credit check. They will ask you for your rental history, either on the application or in person. They will also probably ask you for references, as well as proof of income. This can be either like W-2s, pay stubs, something to prove that you'd be able to pay your rent, an ID of some sort of identification, an application fee occasionally, depends on the landlord, and as well as household composition, who's going to be living there, how many people are going to be in the unit when the lease is signed. And finally, they can also most likely will run a criminal background check as well. Typically, landlords will charge either a move-in fee or a security deposit for new tenants. A move-in fee is a non-refundable fee that a landlord charges a tenant when they move in. It should be related to the cost of the tenant's move-in. A security deposit is a fee that the landlord collects from the tenant at the beginning of their tenancy and does not refund until the tenant moves out, as long as there hasn't been any serious damages to the unit, anything beyond the normal wear and tear. When you're signing a new lease, you should ask for a written lease signed by the landlord and signed by you as well. You want to make sure that the following things are on the lease: the names of the tenants who are going to be living in the unit, the landlord's contact information, as well as their name, the start and end date of the lease, monthly rent due, when the rent is due, the amount of late fees if there are any, the security deposit amount that you paid for at the beginning of that lease, who pays for utilities, and how much notice the landlord needs to give you to enter your unit. You want to make sure that your landlord gives you a copy of the signed lease. When moving in, you want to make sure you do a walkthrough with your landlord, make sure that everything's in good condition, that all of the appliances are working, all the utilities are working, as well as document this with videos and pictures, so that in case something happens and there's a problem, your landlord can't say that you caused the damage if the damage wasn't there when you initially moved in. During your tenancy, you're gonna want to keep proof of your rent payments. If you're paying cash, you're gonna want to ask your landlord to give you a receipt. If there are any changes made to the lease, you want to document these written and also signed by you and your landlord, and have both individuals keep a copy. Something to note is that if your landlord decides to sell the building, you do not have to move. The new landlord taking over the building would also take over your existing lease, as well as a security deposit that you paid your original landlord. That would be carried over to the new landlord as well. If your landlord is selling the building, you want to make sure to get your new landlord's full name, address, and phone number, as you did with your original landlord when you first signed the lease. Now you might be asking yourself, what are some basic rights that I have as a tenant? All tenants have the right to not be discriminated against. They have the right to a habitable home, privacy, and the right to receive proper notice. Landlords cannot use your immigration status to intimidate you or force you to move. This would be discrimination by immigration status. Landlords cannot threaten to call ICE, increase your rent, evict you, or shut off utilities for exercising your rights. Within the state of Illinois, there exists the Immigration Tenant Protection Act. It's an Illinois law that prevents a landlord from threatening to evict a tenant or evicting a tenant because of their immigration status. If you're an immigrant, your landlord can't use your immigration status to intimidate you or force you out of the apartment or new unit. Your landlord cannot threaten to call ICE, increase your rent, evict you, or shut off your utilities. You as a tenant have the right to live in a safe, reasonably maintained home and to ask for repairs when they're needed. You as a tenant also have the right to a habitable home. Tenants have a right to essential services and emergency repairs for heat, water, and electricity. and tenants should refer to their lease for more information regarding the conditions, any possible repairs, and maintenance responsibilities. What should you do if you have a condition or repair issue? If you as a tenant are experiencing conditions and repairs issues, you should notify your landlord first of the necessary repairs. This should be done in writing or in some sort of form that you could provide evidence that you requested a repair. You want to make sure to take pictures of the conditions, whatever it is that's broken or needs repair. Take pictures. Call your local building department if you feel like you must. And if the conditions are serious enough, you should consider seeing if it would be possible for you to break your lease, if they're serious enough to allow you to break your lease. You as a tenant also have the right to privacy. Landlords should typically give tenants notice before entering their home. This is usually about 24 to 48 hours prior to the visit. Except for emergencies, landlords cannot enter a tenant's home without giving them notice. You as a tenant also have the right to receive proper notice. Landlords have to give you written notice to terminate your tenancy. Something kind of related, as a tenant, if you have experienced domestic or sexual violence within your home, something to note is that the Safe Homes Act exists. It's an Illinois law that allows victims of domestic or sexual violence the right to break their lease without being responsible for the rent that accrues during the rest of the lease term. They also have the right to change their locks. And then here is a list of requirements that have to occur in order to exercise the rights that you hold under the Safe Homes Act, but I'm not going to get too into the weeds. Now, regarding security deposits, at the end of your tenancy, in order to make sure that you get your security deposit back, you're going to want to make sure to get all of your possessions out of the unit, leave the unit clean, do a walkthrough with your landlord. Again, take pictures and videos of the empty unit to make sure you have evidence of the conditions that you left the unit in. Return your keys back to the landlord and make sure that the landlord has your forwarding address so that they can send you your security deposit back. Something to note is that landlords, there typically is some lag time between when you move out and when your landlord gives you back your security deposit. They don't have to give it to you immediately on the day that you move out. And now I'm going to turn it over to Anik.
Yes. So this slide is just on the Cook County RTLO, and the RTLO is abbreviated for Residential Tenant Landlord Ordinance. And we just bring this up because this is an ordinance that explains more of the duties between the duties that landlords owe to tenants, the duties that tenants owe to landlords, as well as the rights of both the landlord and the tenant. And so like Leslie mentioned, regarding, for example, security deposit return, if that information, if you live in Cook County, this ordinance might explain the amount of time needed that the tenant must wait before receiving the return security deposit. And so this is applicable in Cook County, so it would apply to those living in Schaumburg, but there are different ordinances in the Cook County area, specifically for Chicago, the city proper, Evanston, and Mount Prospect. They have separate ordinances. So, that's just where it might be helpful if you had a specific question. That's when you would call us and we would be able to better look at your situation and see which ordinance would apply, because that would change the answer. And this moves into as well evictions. So even prior to eviction, just termination of a tenancy or ending a lease, that is not an eviction. That is just, the typical move out procedure. And so lease termination is when you have a written lease or a written contract with your landlord. It's typically for a year. And your lease should say when it ends, as well as how much notice your landlord should give you if they don't intend to renew your lease automatically. And it might also provide for you as well that same sort of information saying you may, if you don't intend to renew your lease, maybe you have to give notice to your landlord of that. It's a little different in terms of month-to-month tenancy, that maybe when you don't have a written contract, but you you still pay rent every month. So you're a month-to-month tenant just without that written lease. And in regards to that, your landlord must give you 1 full month's notice to terminate your tenancy. And so with that full month, you might hear it referred to as 30 days, but it has to be a full month. So if your landlord gives you notice on March 15th that they're giving you a month, before your tenancy ends, that would mean that it would have to be at the end of April, because March 15th to March 31st, that wouldn't be that full month, full rental cycle. And the non-renewal of the lease, so that it's if your landlord gives you notice that they don't intend to renew your lease, there is no right, a tenant doesn't have a right to have their lease renewed. So if that yearly lease is up, your landlord doesn't have to renew it. And they don't even have to give a reason for not renewing it. Again, just because if it's a 1-year lease, a 1-year contract, the landlord doesn't have to give a reason to end that. Okay, next, sorry. Okay, and this graphic is just breaking out, the eviction process. So the 4 steps, and we'll break them down more, but notice, filing, court, and eviction. So Leslie, on the next slide, already went to notice. And so this is separate from a notice about the end of your lease. You'll see that's included, but there are different types of notices. So before starting the eviction case, before there's any sort of court papers or any sort of information entered with the court, the landlord has to give the tenant a written notice to terminate the tenancy. So that's what we mentioned before when we were talking about, if you're a month-to-month tenant, that would be the example of a 30-day notice. So the notice given that you're ending your month-to-month tenancy, or the landlord doesn't intend to renew to you in the next rental month, that's a 30-day notice. And so that would count as one of these notices before filing eviction. There's also a 10-day notice. So that is in terms of lease violations. For example, if your lease says you're not allowed to own a dog and you bring a dog into your apartment, then your landlord might give you a 10-day notice. And a 5-day notice, this has been, perhaps common during, the pandemic. There have, been more non-payment cases. And so a 5-day notice is a notice the landlord gives a tenant for non-payment of rent. And so with that 5-day notice, typically, I think, Leslie, if you could click the next slide, I think I have an example of what a 5-day notice would look like, because again, it is, more common. And again, if you live in subsidized housing or you have a different local ordinance, that's another example where you might want to call, because the information will be slightly different in those cases. But the sample of a 5-day notice, something important to note is that at the end of the 5 days, that the 5-day notice is not giving you 5 days before you're evicted. What it is it's saying you might owe 2 months rent. The landlord is saying, here's a 5-day notice for you to pay all of the rent you owe me within 5 days. Otherwise, I maintain the right to file a court case. So it doesn't even mean that at the end of the 5 days, there will automatically be a case in court. It's just another step the landlord has to take. And so partial payment of the owed debt isn't enough to prevent the landlord filing an eviction. So if you owe $2,000 and you pay $1,000, that's still, there still is outstanding rent, there still is non-payment. So the landlord could still proceed to bring an eviction case, unless you and your landlord have some sort of written agreement regarding that situation. And so again, I just want to stress that if you get a 5-day notice for non-payment, it doesn't mean that you'll be evicted in 5 days. And the notice is just the first step. And then the next slide, we'll talk a bit more about filing. So this is after the notice period has ended. So whether it's 5 days for non-payment, 10 days for lease violation, or the 30-day notice that the landlord no longer intends to renew to you, then the landlord may file a complaint. And what a complaint is it's kind of just the eviction case. It's saying, here's my issue. The tenant wasn't paying rent, the tenant violated the lease, so stating the issue. And they can only do that once that notice period ends. And then you don't have to worry about, oh man, what if I don't know? How will I know if my landlord filed a complaint? Because the landlord will also file a summons. And so the summons is that piece of paper that will be delivered either by the sheriff or a process server who's just a person specifically hired to deliver this to you. And so they will try and serve you with the complaint and summons. And what that means is they'll come and they'll knock at your door and they want to hand you in person or another member of your household who's over 13, the piece of paper that will explain, you have a court case, here's the day to show up to court. And so that's the next step. If if there's the notice period is ended, the landlord has filed a case, then Leslie, if you click the next slide, we'll talk more about the court process, but this is also a sample complaint. So this would just explain what the landlord is requesting. And so what the landlord might say is, I want this person out. So that would be possession, is they want the apartment or unit back. Rent, so that's, if it's non-payment, the landlord might say, I want the rent, and they can request both possession and rent. So that's, I want the apartment back and I want the rent money, as well as any attorney's fees from filing or representing them in the case. And so the third step is the actual court date. So it's important to know that if there's an eviction case, before there's ever an eviction, actually carried out, you will have a court date. And it's really important that you show up to that date, if that happens. So on that complaint and summons, it'll give you, which courthouse you're meant to go to, which courtroom, what day, what time. And typically now, usually it is Zoom court, virtual court. Now there's a little bit more of, you can either show up on Zoom or you can come in person, but there should always be information about how to virtually join. And so it's just really important that you go to court on that day and on that time, because if you just miss it completely, the judge may just enter a default judgment. So that skips any sort of negotiation or defense you might raise, which is saying, hey, this isn't fair and here's why. Then the judge could just say, okay, you know what, I'm entering this, so I'm ruling in favor of the landlord because the tenant didn't show up. And of course, we always encourage if you ever get, as a tenant, if you ever get a notice or court papers or something that you might think is a notice or court papers, you can also call us. And we will be able to, if you send us a copy, we'll look at it and go through it with you to figure out what's happening. And we just mentioned eviction defenses and settlements because, again, at this first trial date, you can raise a defense, which is just saying, here's my argument why I'm in the right and not my landlord. So you are allowed to do that at that time. And you might also, before any sort of eviction is filed, you might work out a plan with your landlord, whether it's, figuring out a move out date or a payment plan. And so what this is an example of an eviction order if the judge says, I am going to enter an eviction order. And what that means is you would actually be evicted. And I will get into that on later slides, what an actual, a forcible eviction or what it looks like when eviction actually occurs. But if an eviction is to happen, there will be an eviction order. So as you can see, it's a specific order. It's a form that would be filed with the court. And it would, the court would enter whether they're awarding the landlord possession, which is, the landlord getting the apartment back, or a money order, which is saying you owe X, Y, Z to your landlord. And this is just zooming in because it'll give you the date the tenant must leave the property by, and you can see it also give you the money amount. So we really want to stress with eviction enforcement, if an eviction order is entered, the only person who can actually remove you and your belongings from the property is the Cook County Sheriff. Again, this is, if you live in a different area, if you live in Lake County, that would be it would just be a different county sheriff. But for Cook County purposes, only the sheriff can perform the eviction. Your landlord cannot be the person to go into your apartment and remove your things. If your landlord says, you have to be out of here in a week or I'll move your stuff out, that's not how it works. They can say that, but that is not legal and that's not how it should be carried out. Only the sheriff's office can perform the eviction. And that would happen by the landlord giving to the sheriff a copy of the eviction order to carry out. And it's just important to note, especially in winter, in Cook County, if the weather is below 15 degrees or if it's really bad, like really icy and cold, they will not perform evictions during that time, nor between December 17th and January 2nd. So just something to note, again, for Cook County. And in terms of if there is an eviction order entered and performed, there can be, that can be on your record if a future landlord searches you in a background check or just, searches public records. But it's important to note with eviction sealing. So eviction sealing is, even if there's this order entered, what it does when it's sealed is that information is hidden from the public. Even if it would normally be searchable on the internet, on a public record, this information would be hidden from that view so that you're not, potentially if a landlord looks it up, that it doesn't affect you in your future. And another thing is residential evictions. So residential being, you in your apartment, in your home, not as a business. Any evictions filed between March 9th, 2020 and March 21st of this year, those should be automatically sealed. So you wouldn't even have to worry about that. It would just be automatically sealed. For other evictions that occur outside that period, the tenant would have to request the court seal the case, as well as there have been some different changes in the law regarding cases being sealed. So if you have a prior eviction or one that you're not sure if it's covered in this period, you could also contact us to see if an attorney on our staff would be able to perhaps file a motion to seal that eviction order. And then it's back to Leslie.
Thank you, Anik. We're going to jump into discussing COVID-related policy and court-based rental assistance, or I'm sorry, rental assistance in general. So tenants who haven't been able to pay their rent due to COVID might be asking themselves if there's anything protecting them from being evicted right now. Unfortunately not. The Illinois state moratorium that existed during the pandemic, or the earlier stage of the pandemic, expired on October 3rd of 2021. There are no current protections for individuals who are unable to pay their rent due to a COVID-related loss of income. There are rental assistance options available for individuals who haven't been able to pay their rent because they've experienced some sort of COVID-related loss of income. Here is a list of available rental assistance programs that are still taking applications right now. There is the Illinois Housing Help Program that's statewide. There is the court-based rental assistance program for non-Cook County residents. There's also a Cook County court-based rental assistance program for Cook County residents. There's a separate program for the city of Chicago. So it kind of depends where you live. That'll kind of dictate which program you would be eligible for court-based rental assistance. And finally, there is the Federal Emergency Rental Assistance Program of Lake County. This program is only for individuals who live in Lake County. If you'd like to see all the other rental assistance programs that are available in the state of Illinois, you can also visit the Housing Action Illinois website. This link will take you there. For the Illinois Housing Help Program, this program is through the Illinois Department of Human Services. You do have to have a referral from an IDHS partnering agency in order to apply to this program. To get connected to one of these agencies, please call the IDHS helpline. It's 312-793-1546. You can also visit the IDHS website. You could search up IDHS, Illinois Housing Help referring agencies, and it'll take you to this website where it'll give you a list of all of the agencies based by county. You should contact the one closest to you to see if you can set up an intake to discuss possibly getting a referral with one of those agencies. It's still ongoing. You could get rental assistance, utility assistance. There is no maximum amount of assistance that you can receive, but there is a maximum period of time that you could apply for, 12 months of past due rent and up to 3 months of future rent. Last time I heard, these funds are starting to run out. So if you are looking to apply to rental assistance, specifically this program, I would advise you to contact a IDHS partnering agency as soon as possible. There is some eligibility criteria for this program. You have to be behind on rent for at least 30 days, live in the state of Illinois, fall under at least 80% of the area median income. This kind of varies depending on the size of your family. You have to have experienced a financial hardship either directly or indirectly due to the pandemic. Like you lost your job, your place of employment closed down because of the pandemic. You had to quit your job to take care of your children or take care of another individual, or you got sick and couldn't work for a period of time and ended up getting fired. Anything related to COVID that directly or indirectly affected your financials, your income, would allow you to be eligible for this program. Something to note, immigration status does not matter for this program. This is a list of documents that your housing provider would have to submit with the application. This is a two-part application. Both the tenant and the landlord would have to work together to fill out this application. I'm not going to go over all of these topics or all of these documents because this presentation is for tenants, and this is a list of documents that landlords would have to provide. So, and the agency would contact the landlord and let them know what they need for the application. So tenants shouldn't be worried about, getting on their landlord and making sure they submit their documents. However, this is a list of documents that tenants have to provide: an ID, a utility bill or proof of address that has your address on it. If your ID doesn't have your current address, this is necessary to prove that you live in the state of Illinois. You also have to submit documentation of your monthly rent and the amount past due. This can either be like a notice of past due rent or your lease or both. Proof of your household income in 2020, pay stubs, bank statements, W-2s, income taxes for the year 2020, as well as proof of public assistance if it's applicable to your household. You need to submit your email address, a copy of your lease, and finally, again, you do not have to submit proof of immigration status or a social security number for this application because they don't ask for your immigration status. Now we're going to hop in to talk about court-based rental assistance. Court-based rental assistance is the latest rental assistance option for individuals who are currently facing an eviction case because they weren't able to pay their rent. This program is designed to get rental assistance in an expedited manner to individuals who need it the most and are most at risk for homelessness. There are currently a couple of different court-based rental assistance programs, one for Cook County residents, another for non-Cook County residents, and then another one for the residents who live in the city of Chicago. So again, depending on where you live, that would dictate which program you'd be able to apply for. Tenants who have previously applied to other rental assistance programs are encouraged to still apply if they're waiting for other applications to either be approved or denied. You should still apply if you've already received a summons and a complaint due to non-payment of rent. Ooh. Now, for Cook County residents who are, facing an eviction case, you should know that Cook County eviction cases are being diverted through the Early Resolution Program, also known as the ERP. This program offers tenants and landlords an opportunity to go through mediation, to receive free legal aid. It's limited to advice and brief services, not direct representation in court, but it is still free legal aid, and can also help coordinate and explain court-based rental assistance, guide you through that process, and also assist through the application process. If you'd like more information, please call the Cook County Legal Aid for Housing and Debt, also known as CCLAD. You can visit their website or call them directly at 855-956-5763. And this is just a graphic of the Cook County Legal Aid for Housing and Debt. Anybody can call like a renter facing eviction, a landlord dealing with an eviction case, if you're being sued for unpaid rent, if you're wanting to sue someone who owes you money, or if you're behind on your mortgage or property taxes. This free legal help is available to both tenants and landlords. Who can apply to court-based rental assistance? There is some eligibility criteria for the Cook County court-based rental assistance. Tenants have to have a pending eviction due to non-payment of rent. A court summons and eviction complaint will be required for the application. So the Cook County has its own court-based rental assistance, and then there is another rental assistance that covers all of Illinois except Cook County and the city of Chicago. Households have to have experienced a financial hardship due to COVID-19, either directly or indirectly, as we mentioned before. That still applies for this program. The household has to have proof of past due rent. This would either be a past due rent notice that your landlord gives you, or some sort of written notice or a written statement by your landlord stating that you owe them rent, or like a ledger. You have to have, your household has to fall below the 80th percentage of the area median income. And again, this is adjusted depending on the household size. And finally, just a reminder, citizenship is not a requirement for this program. So you don't have to worry about applying for this program. If you are an immigrant, that shouldn't restrict you from applying. The court-based rental assistance program can cover up to 12 months of past due rent and up to 3 months of future rent. There's no maximum amount for court-based rental assistance, but the grant payment will be based depending on the tenant documented need. The assistance is paid directly to housing providers or landlords, so they do also have to participate and be willing to cooperate through the application. Where can I apply to court-based rental assistance? So depending on where you live, you're going to want to look up the right court-based rental assistance program to apply to. This is the information for the Cook County court-based rental assistance program. This is the non-Cook County court-based rental assistance program. And if you're, again, looking for like a list of all of the emergency rental assistance that's available in Illinois, you can visit this website right here. This is a list of documents you will have to provide for the rental assistance application. I'm not going to go through them because it's basically the same list of documents that you would provide for any rental assistance program. Finally, we're going to wrap up by discussing how to get a housing referral to the North Suburban Legal Aid Clinic. We can help tenants who are income eligible for our services. The household has to fall below the 250th percentage of the federal poverty level. This varies depending on household size, but for a household of 4, you have to make below $65,500 a year. So if your household has a totaled income below this amount, you would be eligible by income for our services. Again, we provide our services to tenants and tenants only, renting in either private or subsidized housing. The tenants we serve have to live in either Lake County or North Suburban Cook County. If they're facing an eviction case, that eviction case has to be happening at the Skokie, Rolling Meadows, or Waukegan Courthouse. And finally, we can represent undocumented individuals. If you are undocumented, please give us a call if you're facing a housing issue. We will be able to assist you through that. This is a list of cases we can help with here at the Housing Practice of the North Suburban Legal Aid Clinic. We assist with evictions, landlord-tenant disputes, condition and repair issues. If you're looking to break your lease, that's also something that we can help with. If you're looking to apply to rental assistance or just generally learn more about the available rental assistance that you might be eligible for, we can help you with that as well. We help with illegal lockouts, security deposit, returns. If you received a notice of being terminated from your subsidy, we can assist with that as well. And finally, we can help with reasonable accommodations. If you'd like to contact us to set up an appointment with an attorney, please call 847-737-4042. You can also email us at info@nslegalaid.org or visit our website and request an appointment. And I believe that is it. At this point, if anyone has any questions, feel free to unmute yourself. I believe the Schaumburg Township District Library will now end the live stream, so you don't have to worry about sharing your questions with anybody viewing. Correct me if I'm wrong.
The stream has just